Broadcast is now starting. All attendees are in listen-only mode.
Welcome to today's webinar, everyone. Thank you for joining us. I'm Anna Hobson from HR Simple, and I will be moderating today. Today's presenter is Ashley from Ogletree Deacons, and she will be presenting top 10 HR issues. If you have any questions for her, please go ahead and enter them in the question box, and she will get to them throughout the webinar. If you do need any more webinars for viewing, you can go to hrsimple.com/events. This recording will be up there by the end of today, as well as postings for other webinars from valuable resources like Ogletree Deacons. HR Simple provides federal and state-specific manuals. We make employment law easy. Our books are written by top labor attorneys, and they include topics like vacation policies, employee documentation, and how to fill out the I-9 form. So before we go ahead and get started, I just wanted to go over Ashley's bio. In response to the coronavirus pandemic, Ashley has led Ogletree's nationwide unemployment response team. In this role, she tracks unemployment changes nationwide and provides counsel to clients on unemployment-related issues. In addition, Ashley is the co-chair of the Ogletree COVID-19 Litigation Practice Group. COVID-19 litigation involves all areas of employment law as well as personal injury-related claims. In this role, Ashley has been able to utilize her substantial past litigation experience that includes employment litigation, personal injury litigation, medical malpractice defense, and complex toxic tort defense. Outside of COVID-19, Ashley concentrates her practice in management-side employment litigation, including defending claims against wage and hour, discrimination, wrongful discharge, and breach of contract. So on that note, I'm going to go ahead and pass things over to Ashley so we can go ahead and get started.
Thank you, Anna. Can you see my screen now?
Yes, it looks great.
All right, thank you. Well, thank you all for joining us today. As Anna said, if you have any questions, you can put them in the chat box and I'll be alerted that they're there. I will either answer them as we go along through the presentation at the appropriate topic time, or I'll get to them at the end. Also, you can see here you have my email address. I'm more than happy to answer questions after this session is over. So when Anna contacted me, she asked me to talk about some of the top employment issues that employers around the country are seeing today. So we're going to talk about things in broad strokes and go into some detail on these key issues that employers are facing. Of course, in 2021, a lot of it is nuanced because of COVID-19. We're going to hit some COVID-specific issues at the end of the presentation, but as all of you know, COVID is not the only thing that we're dealing with. So we're going to cover things broader than COVID-19 today. And the first one I thought that we should talk about is really hiring and to some extent retention. So we are seeing across the country that employers in all industries across the board are having trouble retaining employees and hiring new employees. There's clearly a hiring shortage. Some people believe that that is partially due to the enhanced unemployment benefits that were provided by Congress. It is unclear whether or not that is true or not. All of the Republican-led states, all the states have Republican governors, except for two, actually have ended those enhanced benefits. They ended those enhanced benefits in either the end of July or end of June or in July. Since that time, we've only had one unemployment report come out that did not show a significant difference in unemployment after the benefits were cut off, but it was still early and only caught part of the states. Regardless, those unemployment benefits, if you're in a Republican or a Democratic-led state, will be expiring on Labor Day weekend. So there will not be any more enhanced unemployment after Labor Day weekend, and there is no indication from DC or from Congress that those benefits are going to be extended again. So that means any of the extra dollars per week, any of the extra weeks of unemployment, all of that is going to be going away here in just the next couple of weeks, which will hopefully increase the applicant pool for your jobs. Other things that we've seen though across the country, and Ogletree actually did a survey of all of our clients across the country to get an idea of what people are doing. And to give you a little background that I did not give at the beginning, Ogletree is a labor and employment specialty firm. So all we do is labor and employment. We're one of the largest firms that specializes in labor and employment in the country. We have 900 lawyers in all areas, in all states around the country, and some international. So this survey was truly across industry, across populations. And what we saw were some interesting key things that folks are doing to try and hire new employees. One of the biggest ones is reducing or eliminating hiring requirements. So this is including things like no longer screening for marijuana in pre-employment, or no longer screening for marijuana in non-safety sensitive jobs. Some employers are eliminating all drug screening in pre-employment. They are also narrowing disqualifying conditions. So that means it's things like you have to have a high school diploma. Well, now they're allowing a GED, or even removing those requirements. They're loosening aptitude tests. They're easing prior experience standards. Again, the goal is to have a larger applicant pool for their hiring. We're also seeing employers across the country target specific populations. This includes trade schools and community colleges. Of course, lots of employers are targeting each other's employees. And then we're also seeing a lot of targeted hiring for military veterans and for former prisoners. For both veterans and prisoners is an added benefit if you hire folks from those job pools in the form of tax credits. So if you are hiring any of those tax pools, make sure you know about the tax credits that can be provided for your employer. The other things that we're seeing happen around the country are simply an increase in base pay. As we saw the government contracting numbers go up for base pay, and with there being a talent shortage, pay is increasing. We're also seeing a trend of increased signing bonuses. Most are paid after the completion of a probationary period, but not necessarily. We're seeing referral bonuses being given to existing employees if they give good recommendations for people that are hired, and then increased in benefits. This includes more vacation time, more sick time, and scheduling flexibilities. We're seeing this being increasingly important, especially to your employees and applicants who have school-age children. With COVID-19 and the closures of daycares and schools and just sickness, flexibility has become one of the most important things we see for those group of workers that have children and or parents that they have to take care of. We're also seeing across the board increases in shift differentials. So for those hard to hire shifts, really an increase in the shift differential pay. And then also transportation related benefits. So again, increasing hiring pools. You may have people who are farther away or do not have transportation. So those kinds of benefits are going up as part of hiring strategies. And again, I think one of the top issues we're seeing for employers around the country is hiring new folks. From a legal perspective, one thing we want to make sure that you remember are that there are multiple states now that have what we call ban the box laws. For those of you who are not familiar, ban the box is kind of the common term that we use for states that have limitations on background checks for criminal history. So what the goal is here is to get more formerly incarcerated persons into the workforce. So for example, if you were arrested for a drug charge 20 years ago and have been clean since then, they don't want that to be held against you anymore. This map will show you some of the states that do have currently banned the box laws for private employers. If you're in one of these states, please make sure you know about your ban the box law, the specifics of it, because it will impact the kind of background checks that you can run and how you should apply those background checks to applicants. One of the other big issues that we're seeing around the country is how employers are dealing with the new marijuana laws. So this is really becoming an increasing issue around the country. This map shows you the different states where marijuana is legal in some capacity. So the dark green areas show where it is legal for marijuana for medical and recreational use. The light green in the map shows where marijuana is legal for medical use only. And then the blue-gray areas are the states where marijuana is still illegal. What we are seeing, though, is there is a rapid normalization of the use of marijuana throughout this country, regardless of anyone's personal feelings on it. And we are seeing many multi-state employers having to juggle with this map. And again, as you saw in the prior slides, it impacting the ability to hire. But all of the different marijuana laws make testing of marijuana a much bigger issue. Again, pre-employment testing, the truth is the marijuana testing is not the same as alcohol testing. You can't get real instant notification of whether or not someone is high. So what you really need to do in any state where you have light green or dark green is making sure that you know the rules, that you know the testing requirements. And if you do have someone who appears to be impaired at work, it is critical that you note that and you really document the impairment so that you have a reason for testing and so that you can show that there was impairment on the work site, not just use over the weekend, especially in a state where it would be legal for your employees to do that. So this has become a real issue for folks. And so if you're in any of these states where you have the dark green or the light green, please make sure you are digging in and understanding your state's marijuana laws and in your state's testing requirements. But again, when we're talking about marijuana, one of the most important things you can do is, again, if there is some kind of impairment at work, that you are really documenting slurring language, slurring steps, slow to react. Those kinds of things are documented so that you can not only show that there was a good faith reason for the test, but also that you had a good faith belief of an impairment on the job. And again, one of the big things we're seeing is that marijuana use being dropped off of many pre-employment panels in the green, the light green, and the dark green states across the country as people are trying to hire more folks. Another big thing that we're seeing come up for employers across the country has to do with remote work. So remote work has, of course, always been something that has been available, but certainly after the pandemic and after everyone was sit home, remote work has really now become normalized. For many employers, it is a workable solution for a variety of different situations and different issues. It allows for an ADA accommodation when that is required. It has really been beneficial for lots of folks. And what we're seeing as we start to head out of the pandemic is that remote work is going to be the new norm for many employers across the country and for many employees. We're seeing that on a full-time basis, and we're seeing it on kind of a part-time basis, in and out. I'll tell you where I work, they would like for us to be in the office at least 2 days a week, but they're okay if we're remote 3 days a week. It is really an individualized preference for us, and it has worked because we figured out the technology. However, there are a couple of really important legal issues that you need to keep in mind as HR professionals if you are going to continue to allow folks to work remotely on a permanent or semi-permanent basis. The big three out there that you need to work through are mainly your two tax issues, so unemployment taxes and payroll taxes. So historically, those are paid in the place where the person works. That would be in the location of your building. But when we're talking about folks who permanently work remote, they may not work remotely in the same state that they're assigned to. Or you may have a location that's kind of on a state border. So you have lots of people working in different places. And so you really have to go through the unemployment tax and the payroll tax considerations for each locale to determine, are they working at home so much that now you must pay the payroll or the unemployment tax in that location versus in your home location. During COVID, we saw this be a huge issue in the Northeast. New York and New Jersey actually sued each other over this issue because the switch in tax base for all of the folks who used to work in New York City and were then working from home primarily in New Jersey was enormous. So this has become a real issue that the taxing authorities in the different states are really on top of. And you want to make sure you're paying your unemployment and your payroll taxes in the right location. Another issue that we have seen come up is mainly due to a change in law in Colorado. 2 years ago, Colorado passed the Equal Pay for Equal Work Act. This is really a sex pay act. And what it says is a couple of things. First, you can no longer ask applicants in Colorado what their past salary was as a basis for their current salary. The reason for that is historically, females are paid less than males. So if you were in a job that historically paid less, then by asking what your last salary was and then using that as the basis for your new job is a continuation of the problem. Colorado actually went further than that, and now they require in Colorado for you to actually post on your job postings a range or a salary that will be paid as part of your job posting. This became problematic when remote work started, because what if the job is remote and you may or may not have someone from Colorado that could apply? Did you have to comply with this Colorado Equal Pay for Equal Work Act? Initially, that answer appeared to be no, as long as you put in your posting that you were not going to take applicants for Colorado. But in the last 6 months, Colorado has actually come out and said that that is not correct, that they will apply this law to anyone that takes any applicant from Colorado, and that you cannot use this law as a reason why you would not take applicants from Colorado. So if you are posting for remote work, hyper-technically the Colorado law would apply to any remote posting that is out there. They are starting to enforce that, and more importantly, what we're seeing is there is actually a new group of plaintiffs lawyers in Colorado who are actually using an AI bot to search for postings for remote work to actually bring these lawsuits against employers all over the country based on this Colorado law. And again, they have a bot that they're running through LinkedIn postings and Indeed postings and different online postings to actually see if they can find someone violating this Colorado law. And then they're bringing a slew of actions in Colorado. So it's an interesting little nuance to watch out for, and certainly know about this if you are actually in Colorado. This law went into effect in January, and it has been a game changer out in Colorado. Colorado had a lot of changes to their employment laws this year. They are not the only ones in this bucket. We also have other states that have salary history limitations. You'll see these states in red. They all have some limits to private employers inquiring into or screening applicants on the basis of compensation history. So again, this is not new, and it is something that is spreading across the country. We see more of these salary history limitations in pending legislation across the country in various states. None of the others seem to have a lot of traction at the moment, but that is primarily because legislatures are still so strongly dealing with COVID-19. But we do expect this to pick back up once the pandemic wanes a little more than it is now. Anna, just checking, any questions thus far?
No questions so far.
All right, so we're going to move on kind of from hiring issues and initial employment issues to one of the other big changes we've seen since the Biden administration took over, and that is unionization. So there's a real push for pro-union under the Biden administration. You'll see the gentleman in the back right behind Nancy Pelosi with the mustache. He is the former head of the largest union. He actually passed away just a few weeks ago, and his replacement was just selected this week. But we're seeing a strong push from unions for unionization. This was underway because of, again, the Biden administration is very pro-union, but also the unions are really using the COVID-19 pandemic to their advantage and are really pushing several different pro-union activities based on health and safety and other concerns. We're seeing the targets of unionization being an attack on arbitration agreements. We're seeing an attack on handbook rules. We're seeing a huge attack on joint employer status. Unionizations like for there to be joint employer. They like it easier to be joint employer so they can increase the pool of folks that they would unionize. The new board with the NLRB has already made clear they're also going to attack things like, can an employer use your own email system to advance unionization in a campaign? And the board is, again, very heavily leaning towards unionization. One of the big things to watch in Congress right now, it is part of the second round of the bill that's up now. Of course, what's up now is the Infrastructure Act, but there is a second piece that's coming right behind it that has to do more with families and the people part of what the Biden administration calls infrastructure. And a big part of that is called the PRO Act. It is a big piece of legislation that is being very much fought by most employers. The PRO Act essentially erases right to work states. It eliminates right to work and basically gives everyone a right to unionize instead of a right to be free of unions. Some pro-employer groups have said the PRO Act is a compilation of every pro-union idea that's ever been put forth in the last 20 years, all in one giant bill. It is basically everything the unions have wanted ever in federal legislation, and it is part of this overwhelming package that they're going to try and push through in the reconciliation process. And again, it's called the PRO Act, and it will have deep and long-lasting impacts on unionization and on the employer-employee relationship in this country if it does pass. So definitely stay aware of that as we're seeing things go through. Again, one of the big pushes we're seeing is unions trying to make advances based on health and safety, especially during COVID. They're using that as a way in. If you're in a non-unionized environment and you're not very familiar with unions and you do have any kind of union activity, please make sure you contact legal counsel immediately. There are very special and unique rules to unionization, who can talk to the employees, what you can say, what you can't say. And one of the things that always surprises non-unionized employers is that an employee could make a claim for an unfair labor practice before the National Labor Relations Board, even if your company is not unionized. We have seen a huge increase in those in the last 2 years, again, based on health and safety and COVID protocols. We're also seeing that with mandatory vaccinations and whether or not you can have mandatory vaccinations, that's becoming a unionization issue as well. So unions are really gaining traction currently and are expected to continue as long as the Democrats hold all three houses in Congress, the Senate, the House, and the White House. One of our other major issues that we have seen in the last 2 years is mental health. When we look at the most recent statistics that we have out there, 49% of employees report having less energy from non-work activities, 42% less interested in socializing, 42% trouble sleeping, and 33% more alcohol or substance abuse than usual. Again, that last statistic is very interesting when you consider the change in marijuana laws across the country and this pandemic hitting all at the same time. When we look at what business leaders say, 44% say they have seen a decrease in employee morale since the pandemic began. And I think all of us in HR are very aware that, to just put it bluntly, everybody's burning out, right? People with school-age children are burning out. I have 3 children. Starting the school year felt overwhelming to me this year with COVID, with everything going on, and it was like nobody had a break to get ready for it with everything that has been happening in the last 18 months. We're seeing employees who have been very sick themselves, who are dealing with long-term COVID issues, who have lost family members. I'm from a little small town, and 3 of my high school friends lost parents this past weekend. All of this is having a serious and impactful impact on mental health. And while mental health is a big issue, it is really flooding into the workplace now in a way that we have never seen before. So when we talk about mental health, really one of the most important things we can do is talk about what employers are doing about this and how they are reaching out to assist their employees. Some of the big things, again, do have to do with childcare because of the crush that has had on working parents the last year. So it is making it allowable to use sick days if employees' children's schools are closed or just for childcare needs, allowing more flexibility with work hours if that's possible in your industry. Again, maybe starting earlier so you can actually pick up the kids from school if there's no more after school, or working different flexible hours for your employees. It doesn't mean less hours. It doesn't mean different hours. It just means flexible hours so they can work maybe a different schedule without any kind of reduction in pay. We're also really seeing an increase in employers planning for mental health benefits. I will say, and I'm going to talk about this with vaccine mandates also, but for many of you, you're beginning to or are already considering your health plans for 2022 with enrollment starting in the fall. We are seeing across the nation a very large increase in the mental health benefits that are being offered by employees through those plans. That is something you may want to look at for your employees and thinking about the mental health benefits that you offer. It is also for HR to help remind your employees about the EAP benefits that you probably already have out there. Again, many of you have these programs, but your employees may not have ever needed them before or really know what they are. So it's reminding your folks about those benefits have been a real big thing. And then this last bullet point may surprise you, which is don't forget about the pets. I actually was interviewed by SHRM for an article yesterday where one of the big issues that employers are having to face around the country has to do with people's pets. So many people got COVID puppies and COVID kittens that what we're seeing is that there is a shortage of vets right now. And so if someone has to take their dog or cat to a vet appointment, it is taking hours all day. Some places are having 6-7 hour waits for an emergency vet appointment. And vets are, parts of people's families. So if somebody tells you they were at the vet appointment and it took them 8 hours to get home, they're not trying to get one over on you. It's really becoming a problem for people to take care of their pets. And again, pets do help with mental health issues, which is why I put this random bullet on this slide, because it's a real issue that employers are starting to face today. All right. Next topic that we're seeing across the country is a top issue: non-competition, non-solicitation agreements. Many of you have these agreements. They are under attack, both from the federal government, from the unions, and from state legislatures across the country. Just this week, we've seen Illinois come in with new non-competition, non-solicitation rules. And what we're seeing in Illinois in their recent update is what we're really seeing across the country. So even in pro-employer areas of the country where non-competition clauses are enforced, we're seeing a trend where they are now being limited. And I encourage you to reevaluate your non-compete and non-solicit agreements. So what we're really seeing legislatures and the courts do is look at the employee more specifically and saying, is this a high-level employee or is this a low-level employee? If it's a low-level employee who either is a low-salary employee or low-level in terms of seniority, stature in the company, they're really evaluating whether the non-compete is necessary to protect the business interest of the company. And if that answer is no, then they're being very harsh, if not invalidating these agreements across the board. That is very consistent with what President Biden has put forth and is in some pending legislation now in Congress, which again would limit non-competes to where you had to earn a certain dollar amount to be subject to a non-compete. We're also seeing lots of things about consideration and at-will employment in different areas of the country. Before, in most places, if you had someone sign a non-competition, non-solicit agreement before they were hired, that was sufficient consideration. Now that is being challenged if the person is at will and they're at a lower rate. Again, low-level employees where they're leaving is not really going to hurt the business. So if you do have these agreements, I very much encourage you to reevaluate them based on the state where the person is living to see if they're still enforceable or if there's a way for you to tailor them to continue to keep them enforceable. Another issue is if you are someone who truly has confidential information, you may want to have that part of the agreement in a separate and independent document. Previously, we've always put these three categories together: non-competition, non-solicitation of employees, and confidential information in one document. We felt that made it more enforceable. That is now changing. If you have highly confidential information, because the non-competition agreements are being challenged so heavily, you may want to have your confidentiality non-disclosure agreements separate now, such that if you do have a non-competition agreement be deemed unenforceable, you do not also lose your confidentiality provisions. This is, of course, becoming a bigger issue for HR people across the country. All right, my next in our top topics for HR folks today, not surprising, diversity and inclusion. Of course, in 2019, 2020, we saw a lot of strife across the country based on racial divides. That is continuing. We are seeing diversity and inclusion becoming a bigger and bigger issue with companies of all sizes in all industries. We are also seeing a really interesting change with shareholders. So with our publicly traded companies, diversity and inclusion is actually becoming something that is being publicly reported and demanded by shareholders. As it goes into that realm, it just trickles down to smaller employers. So diversity and inclusion, looking at different ways to make diversity and inclusion better within your companies. So one of the ways you can do that is really looking at your hiring. Your hiring does not matter whether you're working at home or whether you're working remote. We did get a question about how you can make programs more prevalent when you're still working from home. And I think when we're talking about people that are working remote and from home, one of the best things we can do is use our technology. You can still have business resource groups have sessions for those folks that are with Zoom that allow for there to still be some congeniality. You know, maybe that's for working parents, maybe it's for your African American group, maybe it's for your veterans, for your different business resource groups. You know, it's better when we're in person and we're face to face, but we do now have technology to still work that in. Also, one of the big things we see with remote employees with diversity and inclusion has to do with training your management to make sure your management knows how to include everyone when they're working in remote meetings. It is often the same person who likes to talk up in a remote meeting that wants to talk up in person, right? That person is always raising their hands and always talking out loud. You want to make sure your management is calling on everyone in your remote meetings as well, and that you don't have people who are more introverted disappear into the remote work environment, that they're still called on, that you're engaging with them, but really just reaching out to them through the technology tools is the best thing that you can do, because you do want to keep people engaged. I will also say that working from home is one way, in remote work, is one way that you can actually increase diversity and inclusion, because it can help you increase your applicant pool if you can have people from further away from your home workplace be included in your applicant pool. It allows your applicant pool to be bigger, which is generally how you practically speaking, increase diversity and inclusion in your workforce. When you have a larger hiring pool, you get more diverse applicants. So that is actually a good thing about remote work and COVID-19 as far as diversity and inclusion is concerned. All right. Our next topic, I'm going to switch a little bit into COVID. In some ways, I know that we are all sick of hearing about COVID in HR, but it is not going away anytime soon. And we do have some really important new issues that are key to keeping it top of mind for our HR community. So the first thing I thought I would do is give you guys a little breakdown on what COVID-19 litigation looks like. So roughly speaking, there have been almost 4,000 cases filed in federal court related to COVID-19. This map is a couple of weeks old now, but it gives you a good idea of where you see lawsuits being filed. So where you see lawsuits, the most lawsuits being filed are in either those places that closed down the hardest, like California, or where we've seen the highest number of COVID-19 cases, Texas, Florida, the Northeast, or where we've seen states have the least amount of restrictions based on COVID-19. In some ways, that makes a lot of sense, because if you had the least amount of restrictions, employees panicked that you weren't having enough COVID protocols. In the places that were most restricted, you have employees that were panicking and filing lawsuits because your protocols were too restricted. So it went one way or the other as far as COVID-19 lawsuits have been found. Generally, we see about 300 lawsuits being filed a week related to COVID-19. So these cases are only increasing. When you look at the cases, you can see them by industry also. This is a little deceptive because the healthcare industry is so high. What I will say about this is the healthcare cases were the cases that were filed originally because they stayed open and, of course, were in the heart of COVID-19 battle from the very beginning. We are now seeing the other industries actually catch up to the COVID-19 numbers. If you're interested in diving into this, we actually have this form on our Ogletree website that's publicly available. You can go to this map and all of these states, you can click on it. It will tell you exactly what the claims are in your state. It can give you this industry breakdown, industry by types of lawsuits, so you can really see what's going on in your industry. But when we're talking about the types of claims that have been filed across the country, what you will really see is that they have primarily to do with health and safety. Employees really wanting to make sure you are properly enforcing the CDC guidelines for health and safety, and or they are discrimination suits or retaliation suits related to what's happening. So a lot of these are your typical labor and employment claims that have a COVID overlay to them. So it will be things like, I got fired because I made a complaint that X, Y, and Z coworker came to work positive, came to work and didn't wear a mask in violation of our protocols, did something in violation of your health and safety protocols, not that they missed work for the 10th time, not that they were tardy and in violation of your policies. So it is almost another reason why they've made a complaint that then gives them that retaliation claim. That is the primary claim that we're seeing. We're also seeing claims really increase based on the ADA. Either you're not giving someone an appropriate accommodation or you're not protecting them enough based on the accommodation that they need. So they are the typical lawsuits that we've seen, but with a different overlay for COVID-19. And again, if you want to go back and look at this slide deck that I know Anna's going to give you guys later, this chart just kind of gives you a breakdown of the types of claims that we see versus the industry, so that you can really see what is specifically typical for your industry. Again, with COVID, the big issues we're seeing are compliance. Again, it's really making sure you're staying up to date on the continually changing guidelines on social distancings, on maskings, on screenings, on what to do if folks test positive, on your paid leave requirements in your different states for COVID-19 or for any paid leave, and really staying in compliance with those issues. With the Delta variant, we are once again seeing the rules change, and you really, as an HR manager, have to stay on top of that. I encourage you all, if you are not currently doing it, to follow the CDC and your local state health agency on Twitter. Oftentimes, that's where you can get the fastest news. I also suggest you follow your governors on Twitter. Just this week, we saw that Governor Abbott tweeted out some things in Texas, and Twitter was how that information was released first. Same thing with the CDC. They are always releasing their most up-to-date guidance on Twitter. Of course, it's on their website, but with Twitter, it's something alerting you versus you having to go find it. We're seeing different changes happening again because of the Delta variant. I'm in South Carolina. Just last night, our health agency here once again changed our social distancing and masking requirements for children in our schools. So it is changing again because of Delta variant very quickly. And again, under OSHA, you have a duty to keep your employees safe, and following the CDC and local health guidelines is the best way that you can protect your company from any kind of complaint that comes in due to those guidelines. If you do make a change in your company's procedure or policy based on a new guideline that comes out, I strongly encourage you to date the guidance that you're following and put that guidance in a file. One thing that we've seen in defending these cases that has been a complicating factor is our clients will say, oh, well, we changed that rule because new guidance had come out. But they can't remember the date of the guidance, which guidance it was, and so we're having to put together the pieces. So keeping up with what guidance you're following and when is really critical to the defense of any case that you may have to have regarding COVID-19. And now I'm going to talk about what is probably the top topic of the day, which is mandatory vaccinations. We are seeing more and more companies decide to go with mandatory vaccines or voluntary vaccines with some kind of carrot or enhanced benefit that you can give to those folks. So when we talk about voluntary vaccines with an enhanced benefit, they're very common right now. The only real legal loophole you need to aware of and watch out for is make sure whatever benefit that you're giving for your employees getting vaccinated, whether it be days off or some kind of monetary benefit, is that you know how to tax that benefit, whether or not it would count as some kind of wage benefit or whether it's an additional benefit for which you will have to give them a 1099 for taxes at the end of the year. We're also seeing some employers decide to go with what I'm going to call the stick. For most of you, I'm sure you heard that there's a major airline carrier that decided yesterday to put an additional monetary dollar amount for any employee who is not vaccinated and who is in their health care. That airline carrier is going to charge $200 a month in addition for any unvaccinated employee on their health care plan. If any of you would like to consider that, you do need to make sure that your policy that you're under, your healthcare plan, allows it. Whether or not it does depends on whether or not you are self-funded healthcare or whether or not you're in a broader plan. Even broader plans allow it, but this is all under a wellness group of rules. And it is just like a smoking addition to any kind of healthcare insurance that you may have. It's the same thing. But what you need to be aware of is that all of those wellness plans that have those kinds of penalties for healthcare programs, there is a maximum penalty that you can charge to any employee for the plan, not for the issue. So if you're in a plan and you'd like to add that kind of maybe stick to encourage people to get vaccinated, and you also have a penalty or an additional cost if they're a smoker, the two together could only be so much, and that's a plan issue. So you need to make sure someone who does ERISA plans is able to look at your plan to make sure you will be in compliance if you decide to go with the stick approach to getting folks vaccinated. Of course, there's no requirement that you make your employees get vaccinated, and some employers are not going to go that route at all. They're going to encourage it or not encourage it or just stay silent. We are seeing many employers who go to third-party job sites, though, having an issue where it's the third party who is requiring anyone onto their property be vaccinated. If you're in that situation, one kind of legal issue you need to think about and be aware of, if the third party is requiring you to provide confirmation of an individual's vaccine status, so they want you to give a copy of Ashley Cutno's vaccination card, that could be a problem as far as violation of the ADA privacy rules. It is nuanced, but the way to handle that is to talk to your third party and come up with an agreement that you, the first employer, will confirm vaccination status, but not actually give them a copy of the vaccination cards or a list of your employees who are vaccinated. It's nuanced, but it's important for privacy concerns under the ADA. Also, if you are collecting vaccine information on your employees, it is important to recognize that that is the equivalent of a medical record, and it has to be kept as confidential as possible for you to be able to run the workforce. So really your HR people should know, but not anyone other than that, just like you would do for OSHA medical records or workers' comp medical records, those types of medical records. As far as mandatory vaccinations are concerned, if there has been a tipping point in the scale, we had a subset of employers who were mandating vaccinations 8 weeks ago. Then we saw the tide really shift when we have seen now a mandate for healthcare organizations. In Oregon, we're seeing many healthcare organizations across the country now mandate vaccines. Then, of course, we had the federal government say they're going to mandate it for VA employees and for military. And then just this last week, when Pfizer got their full approval for the vaccine, we are now seeing an overwhelming number of employers consider going to mandatory vaccinations. It is definitely what I'm going to call the current wave, is to actually switch over to mandatory vaccines. If you're going to have a mandatory vaccine program, it is critical that you understand the two exceptions to mandatory vaccinations that you must abide by. So under the ADA, of course, there are some people who, for medical reasons, cannot get vaccinated. If you have someone who asks for an ADA accommodation for a mandatory vaccine, you should do that in the same manner that you would any other ADA request, which is give them your ADA form, have them go to their doctor. The doctor determines whether or not they need an exemption from the mandatory vaccine policy, just like from any other work rule under the ADA. And then you as an employer must determine whether or not you can make that accommodation. Now, a minute ago, we were talking about third parties that your employees may go to, third-party work sites, where the third party is mandating the vaccination. If you have someone who has an ADA issue, please remember that that is an individual assessment. So if the third party is requiring mandatory vaccinations, your employee would go to that work site. They cannot get vaccinated because of an ADA reason. In a perfect world, you will be asking that third party if they will make an accommodation for your employee. The reason for that is because it is, again, an individual evaluation. So one global, no, we're not letting anybody in, doesn't really hit the individual evaluation. Maybe they would for this employee, maybe they wouldn't. But having that in your file can be important when you're looking at your individual assessment of the ADA and whether or not you can accommodate that employee. The other big caveat to mandatory vaccination has to do with a religious exemption. This is where we're really seeing the big fight with mandatory vaccinations come up. In many of our healthcare situations, we're seeing large hospital systems have hundreds of religious exemptions being filed. What we see is that the exemptions are all over the board. And again, you need to have a process and a plan in place if you're going to go to mandatory vaccinations for how you're going to process an evaluation religious exemption request. When we're talking about religious exemption requests, one of the things that employers are doing is they're asking the reason for the religious exemption. They're asking for the religious group, the preacher, the pastor, to actually sign off that this is a part of the religious doctrines culture, that it is truly a part of the belief system of the organization that they get an exemption for this reason. Of course, the number one exemption has to do with the belief that there are tissues are used from abortions that have been used to create the vaccines. There is some truth to that, but it's not in the way most people understand. In the 1950s, fetal cells were used to create the base of vaccines. That base is still what all vaccines are created from today. But anyone who has ever gotten any vaccine has probably had that same issue before. So one question would be, if you didn't object to it when you did a tetanus shot, then why are you objecting to it now? And really challenging that versus making an across the board exemption for that reason, and really challenging why they believe it is a religious objection. Because again, a political objection, while an individual can raise that, legally speaking, it does not get them out of the mandatory vaccination. It must be a religious objection to get them out of a mandatory vaccination policy if that is the way your company decides to go. I will say, and this is going to be my only sales pitch to you guys for the day, if you're talking about voluntary or mandatory vaccinations, we do have a toolkit here at Ogletree that gives you the policy that you should use, these request forms that we're talking about, an outline for how to conduct these interactive processes that you need to do for both mandatory and for voluntary policies. And we have a special set if you are in California or if you have California employees, because their rules are a little different. If you're interested in any of these, again, it gives you all of the forms and policies that you need. Shoot me an email and I'll be glad to talk to you about it more. But this has been a very valuable resource and toolkit that we designed that would be applicable to all employers in all industries. The only exception would be if you're an employer who is in healthcare in Oregon. They do have a special set of forms for that we also have ready for anyone that may need them. The other big part of COVID-19, and it's bigger than COVID-19, but is part of COVID-19, has to do with your paid leave. One thing I wanted to make sure everyone was remembering, the FFCRA, the Family First Coronavirus Recovery Act, y'all remember it mandated paid leave last year if you were a small employer with under 500 employees. This year in 2021, it became voluntary. It covered folks who were out for childcare, for sick employees, for vaccines, for sickness due to vaccines, gives paid leave for those reasons, but it expires on September 30th. So if you are currently taking advantage of this program, be aware the expiration date is coming. If you are not currently taking part in this program, but you're getting ready to mandate vaccines, know that this may give you some tax credit for some paid leave after for people to go and get vaccines. It covers time off from work. It covers if you're sick the next day. But again, it expires on September 30th. And again, currently there has been no talk about extending this deadline. Also, please don't forget, with COVID-19 and the Delta variant ticking up, your different state and local paid sick leave laws. This is the state level, not the municipal level. But again, if you're in any of these states, please make sure you understand your paid sick leave laws and your minimum amounts for your paid sick leaves in these states so that you can go ahead and make sure you're complying with that. So we got a question that's talking about liability waivers upon returning for work. And does that prevent an employee from filing a complaint about a safety or health issue? So filing a waiver never actually prevents any employee from filing a complaint with a health or safety agency. There's no waiver that has ever prevented you from filing a lawsuit. What it may do is prevent an individual from being able to individually recover from some kind of issue that they have, but it would not prevent a report to, say, an OSHA or a state level OSHA entity if something was going on from that standpoint. There are also multiple rules in different states with different legislatures that have passed different laws related to COVID that either protect the employers from contracting COVID on the workplace and or clearly make it a workers' compensation injury if you come back to the workplace and you contract COVID. The reality is it's incredibly different to track COVID unless there's been an outbreak in the workplace. But there are different state laws regarding liability shield statutes or workers' comp that do address that issue. But merely having your employees sign a waiver does not prevent them from reporting to any agency that there's an issue. It may prevent them from recovering individually, but would not stop any reporting. And in fact, they could not stop. You cannot, as an employer, stop an employee from reporting a issue that's coming down the tracks. So lastly, what I wanted to do is point out a couple of things that I really want you guys to watch out for with the Biden administration that deeply impacts employers and HR. Again, one is the joint employer issue. Again, the Biden administration through the National Labor Relations Board is clearly working to attack joint employer. Not only is the National Labor Relations Board doing this, also the Wage and Hour Division pulled some regulations that the Trump administration had pulled out, making it harder to prove joint employer, and we expect them to reissue new joint employer guidelines that will make it easier to show joint employer status, and there will be a new test for that all of you will need to be able to be aware of. Also, again, pending in Congress are what I'm going to call the people part of the infrastructure bill. It is part of what is being debated in Congress now. Part of that is mandatory paid family leave. It also includes not allowing arbitration in certain Title VII situations, especially related to sex discrimination case. There's also a Pregnancy Worker Fairness Act that has already passed the House and is waiting for Senate review. And again, we also talked about the PRO Act, which is, again, basically unions' gift bag to everything they've ever wanted as far as unionization. Also, as part of those larger plans that are going through Congress are mandatory increases in minimum wage to the $15 an hour. All of those things are back up in that next bill that's going to be going through after this first Infrastructure Act gets passed or whatever they decide to do with it. But definitely watch these issues in the next 3 to 6 months to see what is happening with them. All right, we are close to the end of my hour. I know that was a lot. Again, I tried to target on what we at Ogletree are seeing as the most common issues that HR is facing around the country. Again, here's my contact information. I'd be glad to answer any additional questions that you guys may have. I don't see any more in the chat box, but let me scroll back through in the questions. I believe that I've answered all of them. One question that we got was, do I have a right to not come to work if a coworker does not want to get vaccinated? That answer would be no. It depends on your company's policy as to vaccination. What you do have and your employer should be doing is making sure they're following the health and safety guidelines. If you're unvaccinated, there could be a policy such as you have to wear a mask, you have to social distance differently, you have to do things differently than those that are vaccinated. That is currently what the CDC is suggesting. So currently the CDC guidelines are if you are vaccinated, you don't have to social distance, you don't have to wear a mask, but if you're unvaccinated, you do. Now those rules are currently changing with the Delta variant. So if the Delta variant is high in your area, then those rules are different. So for example, I'm in South Carolina, we do have an increasing amount of Delta variant. So previously, my workplace, I am vaccinated, I did not have to wear a mask, and I did not have to social distance anymore. Now that Delta variant's back in place, that rule has changed. I now must mask and I must social distance again when I am indoors in any kind of public space. So if I'm in my personal office with my door closed, I do not have to wear a mask, of course, but if I'm in a public space, I do again. Also, so for vaccinations, if you go to mandatory vaccinations, again, you have to make sure that you have religious exemptions and that you have ADA exemptions where those are applicable, only if they're applicable, but if they're applicable, you have to follow those. And also what we're seeing commonly is if employees don't want to get vaccinated, and they fall into those exemptions, then what we're seeing lots of employers do is require mandatory testing. So it may be COVID vaccine testing as often as once a week. Right now, there's lots of free testing. Ultimately, if there was not free testing in your area and you required it as an employer, you would have to pay for it. I mean, you have to pay for any time that it takes to go get tested for the COVID-19 if you're mandating it as part of employment. Those are other nuances that we cover in that chart that we have. But again, mandatory vaccination, I think we're going to see that far and above be one of the biggest topics that we have here in the next bit. And we're seeing more and more employers go to mandatory vaccinations. I bet we're seeing 50 or 60 clients across our firm go towards mandatory vaccinations every day or two at this point across our firm. So mandatory vaccinations are becoming more of the common than before, where it was not really common for it to be mandated. Now that we see Pfizer getting the full approval, it's getting more attention, and I think we'll only see that number increase when the Moderna drug also gets its full stamp of approval from the FDA, which we're anticipating is going to come in the next week or two, very quickly here down the pipe. All right, Anna, I think I hit all of the questions that